it can sanction the utility. This is the law as written in SB 846 and interpreted in D.23-12-036. This is the guidance that PG&E followed to craft its VPF spending plan, and it's the legal framework and review standard that has grounded CU's advocacy and other parties' advocacy in this case. In fact, multiple parties in this proceeding have successfully persuaded PG&E to update their VPF spending plan. For example, PG&E removed its pole inspection proposal and added 4 new proposals to accelerate distributed energy resource deployment, electrification, vehicle grid integration, and building decarbonization. These are new programs or they're expanded programs that aren't yet funded or included in PG&E's 2023 GRC or its 2027 GRC plans, meaning that spending on these programs will increase or accelerate spending on critical public purpose priorities as required by the statute. In fact, no party has argued that these programs fall outside of the priorities or that the work is already funded, and no party provided evidence that the spending will enrich shareholders. That means the weight of the evidence in the record shows the proposals should be approved. The PD fails to engage in any of this analysis. It fails to weigh record evidence on the proposals, and it fails to explain what it finds lacking in any of these proposals before rejecting all of PG&E's spending plan and directing PG&E to resubmit its spending plan. As we see it, the PD is teeing up parties to relitigate the VPF spending plan, and the Commission needs to shut that down. The Commission should not move the goalpost it's set in its previous decision just because interveners, like TURN, want to force PG&E to spend VPF as they see fit. It's clear from where I sit that TURN does not like the policy of SB 846 and wants to use this proceeding to negate the spending discretion that PG&E has under the plain language of law. If TURN wants to change the law, it needs to go back to the legislature and the governor because the Commission doesn't have the authority to do that here. The Commission needs to revise the PD and stick to the law and the facts and the record. That means weighing the record evidence on each of PG&E's spending proposals individually to determine, 1, whether the proposed spending would support SB 846 priorities, and 2, would not cause double recovery of rates or shareholder profit. And in that process, the Commission also needs to apply the appropriate review standard, which is the preponderance of the evidence standard, not a conclusive evidence standard as referenced in the PD. CU's briefs and comments explain why the PG&E spending proposals comply with the requirements and limitations of the statute and should be approved. And in the interest of brevity, I'm not going to repeat that analysis here. That said, if the Commission is still not satisfied that some of PG&E's proposals are eligible for this funding, it needs to revise the PD to clearly explain why and point to specific gaps in the record. Because without more, it's impossible to know whether the Commission is making a decision within the scope of its authority, which at this stage is relatively limited. And lastly, the Commission should revise the PD to approve all programs that clearly comply with SB 846 without delay. There's no reason to delay funding for one eligible program over concerns that another program might be ineligible. That clearly undermines the purpose of the statute to accelerate or increase spending on SB 846 priorities. Thank you so much for your attention. I'll be around to take questions.
Thank you. Next is Energy Producers and Users Coalition.
Good afternoon. Good afternoon, Your Honor, President Douglas, Commissioners, fellow parties. I appreciate the opportunity to be here in person. It is good to have this chance to speak at this oral argument. This is an important proceeding. And EPUC supports the proposed decision. It appropriately balances the legislative mandate to extend operations with the interest of ratepayers. It rightly upholds the precedent that this Commission set in Decision 23-12-036 in allocating resource adequacy in greenhouse gas energy attributes. So we support the rejection of PG&E's proposal as well to collect a state and federal tax gross up applied to the fixed management fee. And EPUC also supports the rejection of PG&E's volumetric performance fee spending plan. There are 2 minor modifications that would strengthen the proposed decision. First, while PG&E's acceptance of the rejection of its proposed adjustment to the resource adequacy and greenhouse gas-free methodology set in your decision, 23-12-036 is encouraging. The final decision would benefit from a new conclusion of law that PG&E must follow that adopted methodology. And second, the final decision should insist on the detail that PG&E must provide in a future volumetric performance fee spending plan application as recommended by TURN. Those legal requirements should be crystal clear to PG&E. So regarding the rejection of the volumetric performance fee, PG&E failed to meet its burden in providing sufficient detail to enable the Commission to determine whether or not the proposed spending plan meets the statutory requirements. Instead of accepting responsibility for that failure to provide sufficient detail, PG&E is now coming before you to try to coerce you into accepting its vague spending plan by suggesting that not approving the spending plan would harm ratepayers. PG&E is also alleging that if the Commission rejects its spending plan, that's going to thwart legislative intent by interfering with accelerated spending. The proposed decision, however, thoughtfully considers the record and the information that PG&E provided and recognizes that several of the proposed programs do align with your goals for reliability and decarbonization. Even so, the record evidence simply is not sufficient. It lacks the detail necessary for the Commission to conclude that the projects meet the requirements. So we think that the PD rightly rejects the spending plan. Without the proper detail, the utility simply has too much latitude and sole discretion over spending over hundreds of millions of dollars over the course of Diablo Canyon's extended operations. Shifting to the proposed decision's rejection of PG&E's proposal to collect a state and federal tax gross-up applied to the fixed management fees, here again, this rejection is soundly based on the legislature's intent, and it recognizes that Diablo Canyon is different. This rejection should be maintained. The legislature, in drafting SB 846, excluded many types of costs, including the tax gross-up from recovery and rates. The statutory provision authorizing the fixed management fee does not provide for a tax gross-up. The proposed decision appropriately determines that any incremental tax liabilities on fixed management fees should be borne exclusively by PG&E shareholders. Again, Diablo Canyon is different. This is not a business-as-usual shareholder investment of capital. The PD properly notes that a tax gross-up would add significantly to the cost of the fixed management fees, potentially over $30 million, increasing the 2024 to 2025 revenue requirement. I note that TURN has highlighted a possible typo in the calculations of that, so I urge the calculations to be fixed so that the correct total fixed management fee without that tax gross-up is approved in the final decision. Again, the bottom line is that if the legislature intended for a tax gross-up for Diablo Canyon, it would have included that explicitly in the legislation. This is a significant revenue requirement. We're in an affordability crisis, so let's be very, very cognizant of that. I also, in light of our affordability crisis, want to touch on cost effectiveness. Looking at where rates have gone over the past several years and the governor's recent executive order on affordability, the Commission should recognize in its final decision here its continuing duty to assess whether or not Diablo Canyon's extended operations are effective and reasonable. The cost effectiveness of those extended operations is unproven in light of no actual or known forecastable costs for, first, the Nuclear Regulatory Commission license renewal conditions, second, any Diablo Canyon Independent Safety Committee recommendations during the record period, and third, ongoing litigation risks and permitting requirements. We don't know those. we need to keep our eyes on it. So in conclusion, we think the Commission should uphold the proposed decisions, determinations regarding the resource adequacy and greenhouse gas free attribute allocation methodology, maintain the rejection of the tax gross up on the fixed management fees and the spending plan, and keep a close eye on cost effectiveness going forward. I have a little over 3 minutes left, and if possible, I would like to allocate that to turn. Thank you.
Thank you. Next is Green Power Institute.
Hello, hello, commissioners. I appreciate the opportunity to testify today on behalf of the Green Power Institute. We're particularly interested in sections 8, 9, and 10 of the PD, and I believe that sections 8 and 9 are more closely tied to each other than has been acknowledged in the PD or in much of the discussion. PG&E both wants in their VPF spending plan quite a bit, in our opinion, too much latitude and lack of specificity. And at the same time, they want the RA attributes of the extended operations to be allocated a little bit differently than the decision, what was it, 23-12-036, by taking into account the fact that PG&E customers would be putting in more, double the amount per kilowatt hour of VPF funds than the customers in the other jurisdictions. And we believe that as a matter of doing that reallocation ought to be, as a sort of a condition of it, ought to be that the VPF plans should be directed towards the entire state rather than solely exclusively to the benefit of PG&E customers. So we respect the decision of the PD to maintain the RA allocation without a little bit of modification. But we do note that it also removes any motivation on the part of the PD to sort of increase the scope of the VPF spending plan to be more aimed at the state as a whole as opposed to at the PG&E customers alone. That's okay. I think that's consistent with SB 846, indeed. We very much think that the Commission has a role in approving the spending plan, and that the spending plan as proposed right now really lacks any kind of specificity as to what they're going to spend it on. It's just too open, and the PD found that to be the case, and we agree with that. We're very concerned, too, that within the VPF spending, there's a lack of control that guarantees that whatever projects or activities that they pursue will be new or in addition to whatever other activities they're engaged in. A lot of the proposed spending is in existing projects. And to be able to ensure that you're getting additional results from those projects as opposed to sort of using it as a slush fund to provide funds for cost overruns that, for things that were already approved at a certain level by the general rate case, by the wildfire management plan, for example. is a real problem. So we would like to see, in addition to greater specificity in the VPF plan, a set of more specific controls that guarantee that the funds will be used for additional projects. And we also note that it's important to get things moving quickly with the VPF plan. So I would like to see a little bit more encouragement and direction to PG&E as to how to improve the plan to the point where you can approve it. So that would be helpful, and to move the process along as quickly as possible. And finally, Section 10 of the PD talks about PG&E's proposal to substitute an advice letter process for future plans as opposed to the application process that we have right now. And GPI is very much against that proposal because, first of all, we don't even have a first plan approved. And secondly, once that approval goes through and the plan is executed, then we expect the commission to evaluate the benefits and the execution of the plan. And until all of that has happened, I think it's only wise to keep the application process, which puts more authority in your hands to make sure that this is working out. It's a large plan. It's in the first year, $160 million. You can do a lot with that kind of money, but it's what you do with it that matters. So thank you for your time.
Thank you. Next is San Luis Obispo Mothers for Peace.
Good afternoon. My name is Jill Zamek, speaking on behalf of San Luis Obispo Mothers for Peace. I have two main points that I will cover today dealing with prudency and reliability. Why is the Commission not honoring its promise to ratepayers to perform a full prudency analysis? Conclusion of law number 15 on page 127 of the decision in the rulemaking proceeding promised ratepayers a prudency analysis of continued Diablo Canyon operations complete with a cost-effectiveness analysis. Was this promised by the Commission merely lip service to the ratepayers? The answer to this question will be determined by the Commission's actions at the conclusion of this meeting. Currently, the Commission's promise to the ratepayers was an empty one. The Commission's proposed decision is devoid of any actual cost-effectiveness analysis. The proposed decision does not compare the costs of extended operations of Diablo Canyon to the costs of renewable and clean alternative energy resources. Inexplicably, both PG&E and the proposed decision utterly ignore the required cost comparison altogether. PG&E and the proposed decision ignore the need for this analysis, despite the express promise in the rulemaking decision that it is in the best interest of ratepayers and to continue to evaluate the issue. They also ignore the need for this analysis despite the requirements of the prudent manager standard under PUC Section 451, as explained by former New York and Maine PUC Commissioner Chair and former NRC Commissioner, Mothers for Peace expert Peter Bradford's opening and reply testimony. If the time is not right to evaluate the cost effectiveness of Diablo Canyon operations before authorizing PG&E to recover in rates nearly $750 million just for the instant record period, then when will it be the right time for this analysis? Respectfully, both PG&E's and the proposed decision's failure to even address the cost-effectiveness issue is shocking, especially given the balance of evidence in the record. Mothers for Peace expert Mark Cooper gave detailed and apparently the only testimony on cost effectiveness in this proceeding. Mothers for Peace expert Cooper concluded that several renewable and clean alternative energy resources, including but not limited to efficiency, onshore wind, and utility PV, were less costly than extended operations at Diablo Canyon. This testimony went without any meaningful rebuttal. Yet neither PG&E nor the proposed decision referenced Cooper's cost comparison analysis. The Commission cannot hide behind any implied finding with respect to cost effectiveness because pursuant to PUC Section 1705, the Commission is required to expressly and separately state findings of fact and conclusions of law on all issues material to the order or decision. However, the Commission cannot make a finding that Diablo Canyon is cost-effective because the only evidence on the issue in the record is that of Mothers for Peace expert Mark Cooper's testimony that the plant is not cost-effective. Therefore, will be error for the Commission to authorize approval of cost recovery. The Commission's position on reliability is out of harmony with SB 846. The proposed decision on page 78 and finding of fact number 28 states that reliability issues are outside the scope of this proceeding and will be considered in the IRP proceeding. But the rulemaking decision made clear that the IRP proceeding cannot consider Diablo Canyon in IRP portfolios, resource stacks, or PSPs after 2024 for Unit 1 and 2025 for Unit 2. Nor can the IRP proceeding carry out the SB 846 mandate to terminate Diablo Canyon extended operations if Diablo Canyon is not needed, not cost-effective, or imprudent. Moreover, the IRP is for long-range reliability needs over a 10-year outlook. That is ill-suited to address the acute issue presented in this proceeding of whether the current capacity obviates the need for Diablo Canyon and incurring additional costs for Diablo Canyon in the instant record period. Multiple parties, including Mothers for Peace through its expert Rao Conadina, have supplied substantial evidence showing that Diablo Canyon is no longer needed from a reliability standpoint. Mothers for Peace also submitted evidence in the form of testimony from expert Peter Bradford that the reliability is a component of the prudency analysis required by PUC Section 451. Thus, Commission's decision to approve the rate recovery in light of this evidence will be reversible error. As Mothers for Peace expert Peter Bradford has testified, when dealing with events that have low probability but high consequences, the way in which the decision is made is as important as the decision itself. Imprudent decisions are not always followed by drastic consequences. However, repeated imprudent decision-making will eventually have severe consequences. That is the risk being run with Diablo Canyon. Failure to examine the ongoing reliability and economic situation in a comprehensive and prudent manner risks eventually saddling California customers and taxpayers with large economic penalties and perhaps with large safety impacts as well. Thank you for your attention.
Thank you. And next is the Utility Reform Network.
Thank you, Your Honor, Commissioners. Matt Friedman with the Utility Reform Network. I appreciate the opportunity to speak on the proposed decision today. I'd like to talk about the fixed management fee gross up, the volumetric performance fees, and the review of the Department of Water Resources loan proceeds. First, I'll start with the fixed management fee. I want to highlight the fact that there is an error, a mathematical error in the proposed decision. On pages 24 and 78, we talk about this in our reply comments. The error overstates the authorized amount of the fixed management fee because it accidentally includes the tax gross up in the number. We explain all of this in our comments, reply comments, page 1, and we hope the Commission can fix this before the proposed decision is brought up to the meeting because it would overcompensate PG&E by over $34 million relative to what PG&E is permitted under the plain text of the decision. Now let's go to the tax gross-up. PG&E wants the Commission to collect from ratepayers a 42.5% premium on the fixed management fee to cover state and federal taxes. The gross-up is $33.6 million in this cycle, but if you spin it forward to 2030, this item is worth about $230 million to ratepayers through 2030. We believe that the fixed management fee gross-up is simply not warranted and not permitted as a matter of law. SB 846 authorized $50 million a year plus escalation per unit. There's no reference to an additional tax gross-up, and that language in that statute is quite prescriptive and specific. SB 846 expressly prohibits any costs not referenced in the statutory provisions from being collected from customers. And on that basis, last year, in December, the Commission issued a decision in the Diablo Canyon rulemaking in which it said they agreed with TURN that these payments could be outside the scope of what's permissible for recovery and directed it to be considered in this proceeding. The fixed management fee is totally different from a return on rate base that PG&E cites as the basis for a tax gross-up. Unlike traditional return on equity for rate base, there is no rate base anymore in Diablo Canyon under the period of extended operations. PG&E invests no capital. All costs are recovered in the year that they are incurred. There's very limited risks to shareholders under the new framework compared to much higher risks under a rate of return on rate base. There's a liquidated damages fund in case the plant goes out. PG&E can spend up to 115% of its forecast with a complete safe harbor. There's limited disallowance opportunities, no potential for stranded costs. This is a different animal. We don't believe that this type of an incentive is justified for a tax gross-up, and again, we believe it is outside the scope of the law as written. The Commission should affirm the proposed decision's finding that there's simply no basis for providing PG&E shareholders with an additional $231 million through 2030 for this process. Volumetric performance fees. SB 846 authorized PG&E to collect $13 per megawatt hour for generation from Diablo Canyon. It's called the volumetric performance fee, and it's $167 million at stake in this case. But the Commission's decision here will be very impactful because PG&E expects to collect and expend over $1.3 billion in these fees through 2030. If the funds aren't needed for Diablo Canyon, they're supposed to be used to support critical public purpose priorities, which are defined in SB 846. Well, SB 846 also says that the VPFs, volumetric fees, can't be used to enrich the shareholders of the company. Well, ensuring that shareholders don't benefit is much more challenging than PG&E acknowledges. They would have you believe that a sworn statement from an executive saying that the shareholders did not benefit would be sufficient. It is absolutely not sufficient. The key is to make sure that these volumetric fees are only used for certain purposes where shareholder benefits are impossible. Now, PG&E believes that these are effectively shareholder funds and that they can use them pretty much how they please with minimal Commission oversight. The Commission needs to reject this view affirmatively and decisively. As a matter of law, it's just not consistent with SB 846 or the Commission's general authority to ensure that rates are just and reasonable. As a matter of policy, it's bad policy because it encourages PG&E to use this money to benefit its shareholders and to support wasteful and poorly vetted initiatives. Both PG&E and Q here today argue the Commission simply has no authority to reject the plan, to require changes, or to adopt an alternative. This argument ignores two recently issued PUC decisions that address this exact point, where this argument was forcefully rejected. And PG&E, as you may know, has sought judicial review of these decisions, and that challenge is currently pending in the Court of Appeals. Unless they prevail in the courts, the Commission should hold firm and not proactively capitulate on this issue. On the merits, PG&E's plan is simply bad for ratepayers and should be rejected, and we have extensive discussion of this in our testimony and briefs and our comments on the proposed decision. The allocation of these fees to existing general rate case funded expenses would allow PG&E to use these funds to pay for excess spending that would otherwise be the responsibility of its shareholders. Its proposed spending on new programs offer highly questionable value. Some of the programs that PG&E asks you to endorse the funding of today, they invented in their rebuttal testimony. Normally, utility proposes its programs in direct testimony. PG&E changed its whole game plan mid-course in the proceeding and came up with some new ideas for how to spend the money pretty much at the last minute with very minimal support. The programs that they've identified lack key details. There's really no indication as to why PG&E selected them for funding. There's no demonstration of cost effectiveness. There's no cost benefit analysis. They didn't include anything in their ramp applications, no risk spend efficiency. We asked PG&E all these questions. Did you do anything to analyze the benefits that customers would receive from these programs? They pretty much had nothing. That tells you something. This is not a credible showing, and this is not a good use of ratepayer money. Some of the uses we think are categorically ineligible. We don't think that PG&E spending money on its generation assets is within the scope of critical public purpose priorities, and we identified that in our briefs. So what's the alternative to PG&E's plan? Oh, thanks for asking. We actually presented an alternative plan in this proceeding. And in Decision 23-12-036, the decision last December, the Commission specifically encouraged parties to present alternative plans. And they noted that the Commission may adopt alternatives to PG&E's proposal. Well, we relied on the Commission's direction, and we presented an alternative plan in testimony and in our briefs. But you wouldn't know that we presented an alternative if you just read the proposed decision, because the proposed decision doesn't mention the fact that TURN presented an alternative, and it offers no comments or analysis on our proposals in this proceeding. So I encourage you to review our testimony and briefs for a fuller explanation of what we actually put on the table as an alternative in reliance on the Commission's invitation for parties to submit alternatives. Under TURN's alternative, volumetric fees should be used to offset costs tracked in balancing accounts relating to customer energization and wildfire mitigation. We think this avoids concerns about shareholder enrichment. It focuses on the application of these funds to offset capital rather than expense, and it provides long-term benefits through reductions to rate base. In particular, we think customer energization is ripe for this funding. SB 846 lists customer connections and energization as the first critical public purpose priority. And Senate Bill 410, which authorizes interim rate recovery of customer energization projects, requires PG&E to identify any volumetric fees that it seeks to use to cover some of these costs. Well, PG&E has filed two separate requests for additional spending on customer energization. And guess what? Neither of them includes any money that involves the volumetric fees. In this proceeding, PG&E also proposed to use $0 for customer energization. And why? Because they said, well, this money should only be used for expense and not for capital. Why? Well, because spending these funds on capital, in their view, does not align with their business model. In fact, that's what they said when we asked them in data requests. Why? Because it would reduce future profits. Well, the fact that PG&E doesn't want to use the money for that purpose doesn't mean the Commission should agree with PG&E. The Commission should require PG&E to use volumetric fees to offset capital expenditures needed for customer energizations. It would provide long-term savings from avoided depreciation, avoided return on rate base, and avoided tax gross up. So what's next? If the Commission rejects PG&E's plan, we think that PG&E should not be permitted to refile its defective plan until the Commission issues a decision in Phase 2 of Rulemaking 23-01-007, which is the companion rulemaking addressing Diablo Canyon issues. Parties submitted extensive comments in that rulemaking this summer between August and October. We proposed alternative approaches for how to spend the money. It's perfectly scoped in Phase 2, and the Commission is poised to issue a decision sometime soon. Wait till that decision is issued, and hopefully that will provide guidance that will allow PG&E to submit an alternative plan and for parties to be able to suggest modifications or alternatives. We think that ensuring that these fees are well spent is much more important than quick approval, as PG&E requests. The idea that the money needs to spend immediately is simply not persuasive. We want to make sure the money is well spent to benefit ratepayers and not to benefit PG&E's shareholders. The last issue I'd like to talk about is the review of taxpayer funds. SB 846 authorizes, as you know, a taxpayer loan to PG&E, $1.4 billion to cover various Diablo Canyon transition costs. The proposed decision unreasonably rejects TURN's proposal to allow for greater transparency and public participation in the review of the taxpayer funds. We asked PG&E in this case to demonstrate that these taxpayer loan proceeds were not being used to pay for costs that were otherwise collected in customer rates. PG&E simply refused to answer. They said the only place that this review occurs, and these questions are appropriate, is in the PUC DWR review process. We said, well, what proceeding is that in? And they said there is no such proceeding. Well, the proposed decision says this process is public. That would be news to everybody else. There's no public element of this process. There's no opportunity for interveners to participate, to review documents, submit comments, identify issues. So where can we participate and provide feedback to the Commission on the review of these funds to ensure there's no double collection in rates and that the money's not inappropriately benefiting shareholders? No such opportunity has been provided. So our request is quite simple. We believe that the Commission should make this process more transparent, and we have a series of recommendations to ensure that happens. Our concern is that the money could be used to benefit shareholders, and it could be used in ways that misrepresent the source of the funds when they're spent. For example, PG&E claims to have allocated $54 million from this loan to support the REACH program, designed to assist low-income customers paying their bills. But when PG&E announced the funding increase to the REACH program, they said the money came from its shareholders and employees. There was no mention of the taxpayers. Yet, in other forums, PG&E said the money came from the taxpayers. So these are kind of basic accountability issues, and we'd like the opportunity to tee these up for the Commission to act on, and that's why we think that the rejection of TURN's proposal is unwarranted. Thank you for the opportunity to speak, and I'll talk more about some of these issues in my response.
Thank you. Let's take a 5-minute break. Off the record.